Because of this comment, I now have extremely compelling evidence that Blake Lively actually gave New York Times her complaint before she filed it with the Civil Rights Department. This comment says, "This is great research. I don't suppose anyone has checked the metadata on the images in the New York Times article. You beautiful genius." But it wasn't the metadata where I found the date. It's the fact that New York Times labels their hosted images with dates. And this image, if you follow the images linked in the New York Times article, each image is hosted with its own link. And if we zoom in right here, you can see that says December 16th, 2024, which means that unless New York Times mislabeled the date for this, New York Times had Blake Lively's complaint for at least 5 days before they published the article. And it's not just this one. All of the graphics that they used are hosted like that. This one is dated December 20th, December 20th, December 18th, and then this one is from the 21st. There was no date attached inside the actual metadata, or maybe I'm just not technically advanced enough to be able to find that. Why does any of this matter? Well, because Blake Lively's team are trying to say that Justin Baldoni's team are the first people that leaked this information to the press. And yet somehow on the 16th of December, they're able to make the headline image. We already knew because of the timeline, New York Times essentially had to have it in advance. Now I feel like we just know a little bit better about when they definitely had it by. I think this is proof that they had it at least before the 16th of December because they did have to develop this graphic. And by the way, it's really important who gave it to the media first, not who published it first, because the actual rule of professional conduct, Rule 3.6, which Blake Lively's team is trying to say that Justin Baldoni's team violated, in the part where it talks about when you can defend yourself, a lawyer can make a statement to protect their client if there's a publicity not initiated by the lawyer or the lawyer's client. Not initiated. And I think initiated is the important word. It doesn't say published, it says initiated. And if the New York Times started making graphics for their articles by the 16th of December, I think it is very clear who initiated the release to the media. I mean, it was clear before this, but now we at least have a date. Okay, love you guys, drink water, bye. On Tuesday, Blake Lively's team filed a letter with the court asking that the judge get Baldoni's lawyer to basically stop talking about the lawsuits between these two. I've talked about this before, but they're essentially accusing Baldoni's lawyers of violating professional rules of conduct for lawyers, saying that what he's doing could potentially taint a jury pool against Blake Lively. And on Thursday, Baldoni's team filed a response letter. And they say, contrary to the inflammatory allegations, that they actually have not violated any professional rules of conduct. Lively's team is accusing Baldoni's counsel of violating Rule 3.6a. This basically says that a lawyer that's participating or has participated in a case should not make a statement that's outside of the case, like outside of the courtroom, etc. Specifically that they know will be disseminated to the public, i.e. going and giving a statement to the press that could have a substantial likelihood of materially prejudicing an adjunctive proceeding in the matter. Essentially, could this give a potential jury a different view of Blake Lively than just seeing the evidence would give them? Could it make it so that they have a specific bias against her that the evidence wouldn't have given them? The letter goes on to say, putting aside that no such materially prejudiced statements have been made, part of that same rule allows lawyers to make statements required to protect a client from the substantial prejudicial effort of a recent publicity not initiated by the lawyer or the lawyer's client. Baldoni's team is essentially saying, Blake Lively, your team started it and we have the right to defend ourselves. This rule does say that a statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. Brian Friedman does argue passionately and a little bit aggressively, but I don't think he actually provided specifically any information that was not in direct response to something that Lively's team had said, but maybe I'm wrong. Anyway, they're like, you guys gave the New York Times the otherwise confidential administrative complaint filed with the CRD and thousands of pages of original documents, including text messages and email. And they go on to say that the results of that publication have been utterly calamitous for Mr. Baldoni as well as the Wayfarer party, the other people mentioned in the suit. They say that the coordinated public drop of Miss Lively's administrative complaint and the Times story, which the Lively parties do not deny or orchestrate, begin an ongoing attempt to rehabilitate Miss Lively's image at the Wayfarer party's expense. And Lively's team had cited that Baldoni's team had released the raw video footage in the letter when they're talking about how they violated this Rule 3.6. Baldoni's team is like, you guys publicly described the contents of the video. They put out a statement saying that it corroborates their allegations. And down here they say that having publicly made ruinous allegations that the Wayfarer parties can prove are false, the Lively parties now invoke attorney disciplinary rules as an intimidation tactic. It says that if, as the Lively parties letter suggests, they seek out a protective order, it should be denied. Now, one thing is, I have seen people say that a gag order was denied by a judge. That didn't happen. I don't know why people are repeating that. I think like one person made a video and it's now going around. That literally never happened. They have not formally requested a protection order. They requested a hearing, I believe, to discuss counsel's handling of media stuff in the future. But because it would stop Baldoni's lawyer from